Go make sure the screen is showing. Welcome to the webinar. We have a information-packed hour for you. We'll probably go over a little bit more over the hour if that's okay. We have two great speakers joining me, Richard or Dick Weber and Henry Montag, and I'll let them each give a brief introduction for themselves in a minute. The topic that we have today is incredibly important and something that I think needs a lot more attention. Trust-owned life insurance. Tons and tons of clients have insurance trusts that own life insurance. And in my experience as an estate planner, it is unfortunately rare for that insurance to be properly managed. We're not going to focus on crummy powers or provisions of insurance trusts or decanting or modifying insurance trusts, all interesting topics, and maybe it's worthy of doing another webinar. If you're on, you can let me know and we can schedule a second webinar on that. We're going to focus today on the insurance aspects of it because I think it's just so critical and so often ignored. Before we begin, Dick, why don't you say hello, give a quick introduction, and Henry
Sure.
After.
Thanks, Marty. Delighted to be with all of you. I'm an insurance fiduciary. I've been in the life insurance business for 50 years, the last 20 of which acting as a fee only, won't sell insurance, don't collect commission. So I have a position of some objectivity. Written lots of articles on the things that you're going to see today, and I'm really glad that we're going to have this opportunity of bringing you what hopefully is going to be good, actionable information. Henry?
Thanks, Dick. Marty. My name is Henry Montag. I'm an independent CFP, been in practice since 1982. I'm principal of the TOLI Center East, and we do performance evaluations on individually and trust-owned life insurance. Thank you.
I can tell you that I've worked with, and they're quite adept at these issues. And Henry wrote a book recently for the American Bar Association on this very issue, and there's a little plug of the cover at the end if you want to find it. I highly recommend all of you get it and read it. I can tell you that after reading that book on an airplane somewhere, I put a footer on the bottom of my bills and put an article in my firm newsletter, just again cautioning for probably the umpteenth time clients about these issues. You guys ready to take it away?
And by the way, that was co-authored. And by the way, that was co-authored with Randy Whitelaw, by the way. The book that you read, Marty, was co-authored with Randy Whitelaw.
Yeah, everybody heard that. Let's get started. Okay. Slide 5. Henry?
Okay, so again, just thanks, Marty, for putting this together and for focusing the advisor's attention to problems most clients and advisors really aren't even aware of. And that's the increasing number of individually owned and trust-owned life insurance policies that are expiring prematurely. I'd also like to thank Dick just for contributing his expertise and for being here. Over the next hour, we're going to be talking about a couple of things: how insurance policies went from, just say chocolate and vanilla, which was term and whole life insurance, to a Baskin-Robbins multi-flavors of universal life insurance, variable life insurance, universal variable, index universal. We're also going to be talking about how policies were sold in the 80s and the 90s and the effect of reduced interest rates and neglect over the last 20 years on the duration of the coverage. And that's something that I'm going to be spending some time on, specifically speaking of the duration. We're going to be talking about the advisor's role or the lack of it affecting insurance policies. We're going to be talking about the trustee's role and the fact that they're responsible to manage life policies, funding these ILITs and SNTs, special needs trusts, but they don't have the knowledge or the skills to manage them. Current trends is very important, and we'll be talking about what the life insurance industry is and isn't doing, specifically the COIs, the cost of insurances, and we'll also talk about some of the unknown problems, unfortunately handled by spouses or kids or aunts or uncles who basically know very little and are acting as unskilled trustees. We're going to be touching on some current court cases that you should be aware of, and most importantly, some strategies to avoid problems before they begin. So forget the idea of buy and hold and replace that with buy and manage. We're going to be able to talk about the evaluation of performance on an ongoing basis. Now I'm happy to turn the mic over to Dick to be able to get us started on some of the problems.
I want to interject a quick comment, which I think is important for some of the attorneys on the call. One of the problems that we as attorneys and accountants and other professional advisors may face as well is we have a client that comes to us and we may assist them with planning. It could be creating the insurance trust, doing a tax return, gift tax return, and so on. But too often, the trustees who are not our clients may presume they are our clients. So we need to be mindful in our engagement letters to clarify who we're representing. So just keep that in mind. Dick?
Sure. So Henry's already referenced low interest rates have certainly exacerbated some of the things that we're going to talk about today. And our conclusion is, our observation is that I think 23% is low in my own experience. 40 or 50% of TOLI policies are projected to lapse prematurely. That's really, really important, because to the extent that a trust is counting on those death benefit proceeds to be available at the time of death for all the various reasons, if they're not there, that's a huge problem. There have been a number of policy replacements, which that activity suggesting that your old policy isn't working, we should get you a new policy. Sometimes that's true. In my experience, at least half, sometimes 3/4 of the time, we can remediate an existing policy. It does not need to be replaced. Let's go on to the next slide. What we know is, for a variety of reasons, policies often do not perform as suggested by the policy illustration, because the policy illustration is projecting things in fixed factors when in fact most of the policies popular today have some variability. So inevitably the policies wind up being inadequately funded. There have been some issues of companies' financial positions deteriorating, not as big a problem, but certainly in certain instances that can be a case. Cost of insurance has been going up in some types of policies. Perhaps we'll have a chance to visit on that issue again a little later. But the bottom line is that policies are dynamic. Even whole life policies, dividend scales have been going down as a result of returns in their investment portfolios going down. 90% of the insurance industry's primary investments are in high quality fixed return investments. And so as the alternative being variable policies, which has its own set of issues that Henry is going to address. New kinds of policies constantly being developed. The real key is, what's the best kind of policy for this client? Next slide. Really important. Life insurance policies are not self-managing, not even whole life. Whole life requires very little management as long as premiums are paid on time. But if premiums are somehow advanced by cash values with whole life policies because the premium hasn't been paid on time, that's a problem. How could that occur? The crummy gift isn't made in time to meet the grace period of the policy. Inadequately funded life insurance policies, typically the universal type will lapse. And we have a small typo here. Unless reviewed and restructured, it's still 23 to 25% of universal life policies will expire early. And that, I think, is an underestimate. One of the things that we've observed is 90% of all ILITs are managed by non-professional individuals, the brother-in-law, the sister-in-law, who typically do not have the expertise to manage these assets. And that's a real problem under Uniform Prudent Investor Act. Next slide.
So let's
Henry.
take a look at what happens when some of these unskilled amateur trustees have the helm of the policy. Just as an example, Mr. Smith, age 59, purchased $1 million life insurance policy in 1987. Typically, the agent would ask, Mr. Smith, how much insurance would you like? How long would you like the insurance to last? And what interest rate shall we use? Now, keep in mind that this was when interest rates were upwards of 15, 16, 17%. So there might have been a compromise at going 9%. So the premium needed for $1 million to age 95 is $14,000. The application is signed. The attorney was basically asked to set up the trust because back then we didn't have a $5 million exemption. We had more similar to a $600,000 or $1 million exemption. So there would always be a trust. However, there was no mention made of any sort of guarantee of the time period, the fact that interest rates could or would change, that there should be some sort of a follow-up strategy, and that the policy, as Dick said, requires active management. Next slide. Next slide, please. So here we are 30 years later. That 8 to 9% assumed interest rate was not achieved. In actuality, we came closer to a 4% actual interest rate over the last 30 years. Currently, that $14,000 premium will have the insurance expire this year at age 89, not at 95. This is what we meant by the duration. The premium needed today to guarantee that policy carry through until age 95 is actually $26,000, virtually double. The current premium of $14,000 would only provide $450,000 of coverage until age 95. Next slide, please. Now, this isn't Marty or Dick or myself saying that this is a problem. This is also noted by the Wall Street Journal, and here's just a short quote from one of the senior editors of Wall Street Journal. I'm not going to read this for you, but I think if you just take a second to read through it, you'll get the gist.
Let me add a quick comment. One of the issues that we as attorneys and accountants face when we're advising clients doing a gift tax return for an ILET, drafting an ILET, we are not the insurance experts. We are not the people structuring these policies. But some clients may misperceive that we have a responsibility for the insurance decisions. One of the things that I've done for decades is in my standard engagement or retainer agreement, I expressly state that I have no involvement or responsibility for selection of insurance policies or carriers. Something to keep in mind, because we
Really
don't want to
point.
get tagged with something that we can't help if we don't have the expertise. There are some of our colleagues that do have the expertise to address this. Most don't, which is why I always try to get the clients to bring in and involve an insurance expert.
Next slide, please. And on that very point, Dick, the life insurance agent's prime responsibility is to market, not to manage. The insurer's duty is to provide the policy and to provide an annual statement. Basically, the insurance industry's posturing is recently, in addition to the reduced interest rates, sustained reduced interest rates, and in addition to the fact that policies, as we said, been neglected, what the insurance companies have recently done is they've further exacerbated the situation by increasing the internal COIs, or cost of insurance. That's causing havoc amongst, or just further exacerbating the premature expiration of many of these policies. Basically, the insurance company, in my opinion, they're very content with the current situation. Actually, it's in the best interest of the insurer when the contract expires. Next slide, please. Now, here's a copy of an actual annual statement. And if you, by the way, that annual notice important statement, that's my writing up on top. That's not the insurance company saying that. If you look all the way at the bottom, this is page 3. If you look all the way at the bottom, you'll see where it says, changes in interest rates may impact the insurance coverage and cash value, blah, blah, blah. Now, this is what I call the double stage. They're telling you that there may be a problem. There is a problem. And my complaint with this is that rather than pointing out in big black letters, important statement, block letters, the insurance company is merely referring you to call someone else, to call the insurance company to find out what it really is. Some companies actually put exactly how long the current contract will remain in force and how long the guaranteed provision will remain on force. This is just a pet peeve of mine because they're not fully disclosing and they're not communicating the entire picture to the audience, to their insurers.
Keep in mind, everyone, the comment that either Henry or Dick made earlier. About 90% of the trustees of these insurance trusts are lay people, and I'm going to use a term that Henry, I think, coined, or he certainly uses all the time, accommodation trustees, somebody's brother-in-law. These folks not only don't have the background to understand this stuff, but too often they don't even understand that they need to call somebody for help. And we'll talk more about that as we go on.
So
and
some of the, yeah, sorry, go ahead.
Nope, just turning the mic back over to you.
Good. So policy considerations, actually for this slide, we're talking about specifically universal life. And universal life is characterized with flexible premiums. Flexible premiums is great when you have irregular income, but flexible premium also seems to imply to pay as little as you want, and that's a real problem. Point we all want to make is policy performance is based on the trustee's actions or inactions. The policy is the policy. What the trustee as owner does with it is really critical. The premiums are based on current interest rates. They're not guaranteed. The duration of the coverage isn't guaranteed. The maximum death benefit for minimum premium absolutely doesn't work. We've had universal life now for almost 40 years, and there's been a real crisis because a lot of that was purchased and sold with much higher crediting rates than today. Policies that are more than about 10 years old, this is again in universal life, are at their guaranteed crediting rates, which will be somewhere between 4 and 5%. Policies must be reviewed and typically will have to be restructured if they are maintaining on fumes. Again, the 23 to 25% universal life policies are expiring early, and I think that that's a low number. And the reduced interest rates, as well as for some policies increasing cost of insurance, are the things we have to focus on. Next slide. For variable universal life, essentially the thing to realize is nothing is guaranteed. Variable is the one kind of policy where the sub-accounts, mutual fund-like accounts, are actually segregated. The insurance company does not include those account values in their general assets. The policy owner, in this case the trustee, directs how their premiums are to be invested. That can be a huge advantage if the trustee is knowledgeable and experienced in doing that. The agent is not. The agent typically will not provide that information. So variable, as we say on the slide, must be reviewed annually. And truly, the best use of variable is when you intend to overfund and are seeking tax-deferred growth. Next slide.
And just to highlight what Dick said a moment ago, a moment ago, there are three components to this and virtually every other non-guaranteed contract. It's the premium, it's the death benefit, and it's the duration. And as Dick pointed out, neither of these issues have any type of a guarantee in any type of a variable contract, but many insureds are not aware of that.
Right. One thing I would add to that is that we hear comments a lot recently about don't use variable because it's too risky. The policy itself is not risky. How the premiums are delegated into a variety of sub-accounts that range from guaranteed accounts to international small caps type of accounts. That's where the if there is any risk, that's where the risk is, and it's the right policy for a sophisticated trustee to manage. It's not the right policy if that sophistication doesn't exist. The basic math on all universal life is that it's a balancing act between the money that goes in, that's called a premium, the money that is earned, that's on the credit side, and on the debit side are all the various expenses of the policies. And the policy owner, again, in this case, the trustee, their lifetime balancing act is keeping that in balance. If the expenses start overwhelming the credits, we're going to have a policy that's going to slip towards lapse. The last comment then, the current slide, is term insurance. Not often used in ILETs, but sometimes it's appropriate. It's a matter of time periods. Certainly a 10-year time frame, a 20-year time frame. Much longer than that, there may be better so-called permanent solutions. The good thing about term insurance is for the term period, the death benefit and the premium are guaranteed. The problem is historically only 2 to 3% of those policies ever become death claims. The uses for term, of course, classically are family income, college funding, mortgage or loan repayment, and business buy-sell. Next slide. Henry, you've got a case study.
That's the one that we're gonna skip over. We've already covered that with the
okay, good.
Policy.
Okay. So we wanted to talk about variable life insurance just a little bit more in depth. Variable was the product of choice during the 1990s. The stock market was the longest running bull that anyone in memory had seen. The compound annual rate of return in that bull market was over 18%. Agents couldn't use more than 12% in their projections. We asked them why they use 12, and typically they'd say because they won't allow us to use 16. So the variable was very popular and may still be effective depending on the deployment of the sub-accounts. But again, nothing is guaranteed. Both indexed and variable life have to be reviewed for status annually. That would be a good general rule. Every single year, those policies have to be reviewed because the credits to the policy, whether directly through sub-accounts and VUL or indirectly through the point-to-point credit of typically something like the one-year S&P 500, depends on volatile elements beneath the policy. Have to review. Next slide.
So what is our role as an estate planner? Whether you're functioning as an attorney, an accountant, a wealth advisor, you have to gather relevant data. You have to understand what the client's goals and objectives are. You have to talk through with the client who they should name as trustee as well as beneficiary. Now, I don't think anything in our discussion so far has given any impact on who the beneficiary may be, but it certainly, I hope, has had significant influence on who you feel is appropriate to be the trustee. If the client's going to name family as a trustee to save a modest amount of money each year, they had better make sure that the family member trustee, or I'm going to again use Henry's term, the accommodation trustee, that's doing the client a favor by serving as trustee, has to know to have regular meetings with an insurance consultant as well as the other advisors to make sure this stuff stays on track. And apart from all the insurance issues, and I don't want to get us sidetracked on estate planning issues, if you take a look back at the last 20 years and you look at where we're going now in terms of the estate tax exemption, the marginal rates, the law has changed so many times that whatever tax assumptions existed when an ILIT was set up are unlikely to be relevant years later. So we need to meet to review the very purpose of these trusts, and if the exemption doubles, which is one of the current proposals, it will have us reconsider the purpose of all these trusts, but the starting point is, again, the insurance. We need, as attorneys, accountants, wealth advisors, to have a much more poignant, specific, real discussion about who the trustees should be and their real roles and duties. I think it's already clear, and we've hardly gotten through that much of the program, that this is not a task for the faint-hearted or the inexperienced. So we need to really talk about that. We need to stress the importance of reviewing and monitoring and actively managing policies. One of the things that I do in my engagement letter and retainer agreement, in addition to saying, as I already had mentioned, that I will not accept responsibility because I don't have the expertise to review insurance policies, I have, and it's actually over the years, now it's grown in dimension. I had a phrase many years ago that if you don't have an annual review, your planning won't work well. I now have a statement in my engagement letter: if you don't have an annual review, your planning won't work, period. And over the last few years, that has now been underlined and put in bold. It is critical for all the reasons we all know, and not to mention the rapidly changing estate planning environment, that clients come back for a periodic review. Everything Dick and Henry has been talking about and will continue to talk about requires periodic review. So the trustees need to understand and be realistic whether or not they have the expertise to do so. And if they don't, there's great smart people out there like Dick and Henry that they can hire to help them, as well as working with the insurance consultants that they've started with. They need to understand that they do have a fiduciary liability for maintaining and maximizing and achieving the goals of the trust, and many do not understand that. There could be obligations under many state laws for the trustees to communicate with the beneficiaries and let them know what's involved with the trust. Few accommodation trustees do that. They need to make sure that they bring in the right consultants to do it. They need to have forecasts and projections done to see where this insurance coverage is going and whether or not it will accomplish its goals, and to reconsider a whole range of things, from changing estate tax rules, changing income tax rules, changing economics with longevity. Can the client continue to afford putting the gifts in the trust? One of the issues, and I just want to touch on it here because I don't know that we'll get to it elsewhere, clients that may have thought they would live to age 85 and their financial advisors did projections to 85, and now they live to 95 or later, will they be able to afford continuing to fund those policies under the prior assumptions? So longevity may work against the funding. Henry, let me turn it back to you.
Well, the objective, as far as I'm concerned, is to be able to lengthen the guaranteed duration of coverage so that the policy will outlive the client. And there are really 5 options to be able to do that. One, of course, would be to pay a higher premium. 2, of course, is to reduce the face amount. Now, these things are relatively simple if you know that they lack in paying a higher premium, or that they should, in fact, reduce the face amount. Another option is to be able to obtain a new contract. 1, if the individual is qualified, and 2, if it makes sense for the client to do that. I want to go back to Dick's point. Many times an existing policy can be manipulated internally to be able to do several of these items, whether it be to pay a higher premium or whether it be to reduce the face amount. I'd like to talk for a moment on 1 or 2 current and selected court cases. I'd like to start with the estate of Schneider versus Finman. Mr. Schneider was working with an attorney, and in doing some estate planning for him, $1 million, by the way, Mr. Schneider was single, $1 million life insurance policy winds up in Mr. Schneider's estate and was subject to estate taxes when he passed away. The kids, being educated, felt that there was something wrong with that picture, that $1 million policy turned into a $500,000 policy. So the kids brought an action against the attorney, but they were advised initially that there was no standing privity pursuit. The kids decided to pursue the matter, and lo and behold, they were able to have the matter overturned by New York State's highest court. So the outcome is that the estates and beneficiaries can now sue the estate planning attorney for malpractice. So for the first time, allowing a personal representative to stand in the grantor's shoes. Senior counsel at Proskauer Rose said that this decision is going to change the dynamics forever between the estate planning attorney and the client. In another matter, Stuart Cochran, we have with us Dick, one of the expert witnesses in that matter. So rather than my speaking on that, I know you just finally took a deep breath, but perhaps you might be able to a little bit better on Cochran than I
Sure.
can.
And just a quick thumbnail. So Randy Whitelaw and I were the expert witnesses for the Cochran family. There had been an $8 million variable life insurance policy in the irrevocable trust that was managed by an institutional fiduciary. And after the what I called the mama bear market, when the market started declining in 2000, the trustee decided to exchange the variable policy, the $8 million variable, for a $2 million guaranteed death benefit policy. And ironically, Mr. Cochran died a year later. It was contestable, but there were no contestable facts. So the death benefit of $2 million was paid out, and the family sued the bank for irresponsible management of the policy. It was a bench trial. I gave testimony for a day and a half, the judge and I basically talking to each other. Randy, pretty much the same. The bench trial, the judge took almost a year to render his decision. Surprisingly, he found for the defendant, found for the bank, on what seemed to be the single thread that the bank had reached out to a third-party expert to get advice about the $8 million VUL and what it should do. The advice was, watch it. But in fact, what the bank did was replace it. That was sufficient for the lower court. It was affirmed by the state Supreme Court. And the point, I think, of Cochran is that based on certain facts and the judgment of those facts, that the trustee, the institutional trustee, was found not to be blamed. But I don't think trustees of any kind, personal or institutional, can take much comfort from that. And frankly, I think there's new blue ocean with respect to lawsuits by beneficiaries against trustees when the policy goes bad. Not that it may or may not be legitimate that the trustee did something wrong, but the beneficiaries are much more likely in this environment to sue the trustee, and that's something we have to be aware of. Back to you, Henry.
Thank you.
Let me interject a comment. I think the lesson of all of this on everybody on the call, whether you're an attorney, an accountant, an insurance consultant, a consumer, everybody on the call, you want to have, I would still recommend an annual, but certainly not much more than, less frequently than that. But you really should have an annual review where all the advisors that have input on the particular insurance trust, the attorney as to the terms of the trust, the accountant perhaps as to some of the GST, gift tax, or gift planning implications as well, the insurance consultant as to the insurance implications, and to take a look at the overall facts and circumstances. How have health factors changed? How does that influence it? One of the things that we've done more commonly, because it's become so readily available and so inexpensive, is to hire a firm, and it really grew out of the life settlement market, that can do a real life expectancy analysis rather than using tables that may not apply to our client. It doesn't really take a lot of cost and a lot of effort to try to keep up with this stuff, but these meetings, just in my experience, rarely happen. And I think a lot of times clients are reluctant to spend the few dollars to get their advisors together, and it's a tragic mistake. I'm sorry.
And I would totally agree with that. We tend to recommend, certainly for any client age 70 or older, 21st Services will do a simple life expectancy projection for $150. It's money well spent. This is something that we have to be evaluating, not just the policy, but all the factors surrounding that client and the trust-owned life insurance on behalf of the beneficiaries. This has to be actively managed. Couldn't agree more.
And let me just add too, the wealth advisor needs to be involved in this. What is the cost of funding the policy? How does that affect the client's cash flow for the duration of their life using a reasonable, conservative, reasonable life expectancy, let's say 95 or even 100 years? There's a lot of different factors that have to be looked at, and yet for reasons that I cannot fathom, and especially after hearing Henry and Dick talk about these issues, so many clients and so many trustees seem to think, we bought a policy, we don't have to look at it for decades. Why do we ever have to look at it? You do, and it's a terrible mistake. And I think the way to get clients educated to do this is for every advisor, whatever hat they wear, to drill and educate clients the same message. You got to sit down annually with all your advisors and look at this stuff.
On that point, I just like to comment that we started out many years ago with term insurance, which was guaranteed, and whole life insurance, which if you didn't mess around with it, if you didn't use dividends,
count on the dividends,
right? If you didn't use dividends to buy term insurance, those two contracts were basically guaranteed, and you could take those policies and put them in the bottom left-hand drawer and forget about them. However, that's no longer the case with today's policies. As Dick and Marty just mentioned, people are confused, and people still have that buy and hold mentality when they've got to get rid of that. And more so them, the advisors have to drill that into the client, that those policies are no longer just buy and hold, that they've really got to look at those policies because they do have a lot of moving parts. And as we've said before, very few pieces of that today are guaranteed, and clients are not aware of that. So it's really the job of either the wealth manager, the insurance consultant, the accountant, or the attorney to remind and to perhaps even use some of that parental authority to gently nudge the client toward having somebody take a look. Look, we know that it's not fun to look at an existing insurance policy. One, people emotionally don't want to do it. Two, they don't understand it. Three, in some cases, they don't trust the individuals delivering the information, and therefore they avoid it. But avoiding it today can be a very, very costly mistake. Right. Can I get you to just go back one slide to 25? Thank you. I just want to spend just a quick moment just talking about the life settlement option. Several years ago, in Larry Grill versus Lincoln National, a client had several $1 million of life insurance that he could no longer afford. So he set up a meeting with the agent and with the insurer, And the suggestion was, well, if you can't afford $7 million, why don't you give up $3 million and just keep a $4 million life insurance policy? So the client took the advice, and unfortunately, several years later, the insured died. And again, there was some talk about the fact that he could have sold the $3 million and perhaps received upwards of $1 million, $1.5 million for that. Instead, he just basically gave it up and received nothing for it. Basically, the agent agreed that the company did not let him speak on the subject of life settlement. Why? Because insurance industry, insurance companies in general, can count on upwards of, I've heard, anywhere from 8 to 10% of the built-in profit by policies that either expire prematurely or policies where the contract is just basically given up for its cash surrender value. So again, it's just an issue that should be looked at regardless of what the outcome of the current court case is, because that matter is still being knocked around. And to this very day, there are still many career shops that prevent their agents from discussing, from even thinking of the subject of a life settlement for the very reason. It's a profit center. It's a built-in profit center for the insurance company, and they don't want to see anybody messing around with that.
Let me ask you both a real quick question. So if an attorney or an accountant recommends to the client, you haven't had your insurance coverage and your insurance trust reviewed for years, and the client brings in the insurance agent that sold them the policy, and now with the much higher exemptions, a lot of these policies and trusts were sold when we had $1 million exemption. Now it's a $5 million inflation-adjusted exemption, which may pop up with tax reform to double that. And people may no longer want to pay for these policies. Is this a concern still, that the agent who is brought in may not recommend a life settlement, and our clients are not going to get the full array of possible answers that make sense for them?
It's hard to judge there, Marty. Yeah, I think that there still are some of the traditional big mutual carriers that to some degree limit what they allow their agents to talk about on something like life settlement. By far the greater number of agents who may have sold policies probably are producers who are not tied to a specific carrier, and so wouldn't have that same limitation. But I definitely would want to know from the original agent, if he or she is still involved, if there are any such restrictions, and if so, they may need to recommend someone else come in and have that conversation. It's not sufficient to say, I'm sorry, I can't talk about that. Then the obligation of the agent is to recommend someone who can talk about it.
Absolutely.
The point is, the safer thing for the advisor may be to recommend that the client get an independent analysis of the policy.
Yes, absolutely.
Okay.
Agreed.
Absolutely.
We'll go on, guys.
Why don't we move to slide number 29, and Henry and I can start talking about the various responsibilities of the advisor constituents, Marty, just as you were talking about. And the one dilemma is insurance agents are often not involved. Their business model is they have to sell and move on. There are a lot who are very loyal to their clients, but there also are instances, we've all experienced it, where the agent simply has moved on or has left the business. So it's important to recognize that, and that there's no real incentive to service the current policy or the client.
And you realize that the insurance companies can certainly change that, and I think some of them are already involved in looking for a path to do that. Without mentioning names, I know that some insurance companies are now leaving the agent force and are now looking at the RIA force, or looking at the advisor force, where there would be an incentive, and the incentive would be to manage that policy the way that a wealth advisor currently does. The good news would be that instead of a 95% upfront and a 5% ongoing, the insurance industry has the ability of staging that commission to perhaps 20-25% each year, and providing an ongoing service fee that's more meaningful to the wealth advisor or to the agent, to be able to have some skin in the game, to have an interest in managing some of those dollars to prevent those policies from lapsing prematurely.
That probably will start happening over the next few years as the fiduciary standard starts rolling through both financial services in general and the sale of life insurance, but it's not here now. Something, Henry, I think is important. You've said before, and maybe you can re-emphasize it. Even if the agent isn't present, you can't blame the agent. The trustee has responsibility.
Well, you can blame the agent, but it's not going to matter. You can blame the insurance company, but
yeah,
it's not going to matter either. The fact of the matter is sometimes the agent might just be embarrassed that he or she hasn't been there for all of these years. Sometimes the agent might be embarrassed to have to tell, or not embarrassed, but feels funny telling the client that, by the way, that $5,000 premium is no longer sufficient, and we've now got to pay a $6,000 or $7,000 or $8,000 premium. So there are an awful lot of impediments to getting some information from an agent. But as a consumer or as a trustee or as an advisor, there's a wealth of information that that agent can supply or that the insurance company can supply. And it's certainly up to the advisor to take advantage of that and obtain the information rather than just letting the client sit out there and blowing in the wind, waiting until the insured gets that letter saying your policy is going to expire within the next 12 months.
Good. Marty, why don't you quickly cover the attorney and CPA and trustee roles?
I'm going to do this quick because, again, I think the critical issue that is often lost are the things that Henry and Dick are talking about. And we've talked about some of the roles of the attorney earlier. The problem and challenge that I feel personally as an attorney is getting clients to come back and address this. They don't seem to get the need to do it. They seem to be continuing to operate in spite of all the things Henry and Dick have warned us about, under the presumption, a misconception is a better word, that they bought a policy and there's nothing to do. We now know that the whole world in terms of insurance trusts has changed radically. Decanting was hardly spoken of not so many years ago, and now is the law in more than 20 states. And even if it's not the law in your state, you may be able to move an insurance trust to a state that has a decanting statute and decant it, merging it into a new and improved trust that may not be able to change beneficiaries, but can change lots of administrative and other aspects of the trust. If you go to a state like Delaware, or move the trust to a state like Delaware, there's a non-judicial modification procedure that literally lets you change anything if the settler is still alive and all the relevant parties consent or non-object to the transfer. Many of the newer trusts have trust protectors and a range of other provisions. So we can really mold and craft to not complete, but to a fairly significant degree what these trusts do. But the starting point in the analysis is almost invariably, what does the policy hold? Is the policy still a good policy? What are the options that can be done with the insurance? If we no longer need this insurance to pay an estate tax, which many of these, if not most of the insurance trusts were created for, what can we use the policy for? And I've seen, again, two polar situations. One, where clients simply ignore everything and don't meet, or two, where they simply cancel policies without talking to anybody when those policies may have been great policies. So, a physician client may well be able to, if you will, repurpose an insurance trust that was set up to pay an estate tax to an insurance trust with permanent or well-structured and fully funded policies that are a great asset protection tool. We need to get the advisor team and the clients to talk about it. CPAs are often involved in filing the gift tax return or an income tax return. Many insurance trusts don't have enough income to trigger an income tax return, but I've seen a significant change in direction where we're using more robust spousal lifetime access trusts that also double as insurance trust, dynasty trusts, and so on and so forth. And there may, in fact, be a grant or trust return for that. If an accountant is preparing a return, it certainly may not be a bad idea to have a form letter that you send with the client or give to the client with their copy of the 1041, just suggesting some of the things that we've been talking about in terms of changes in the estate tax, review of the policy, so on and so forth. The ILIT trustee, again, I think it's critical that trustees, especially inexperienced or accommodation trustees, get proper help. They should consult with their advisors. They should bring in an insurance consultant to review the policy. That's the way to help protect themselves in their fiduciary capacity. I think even if there's indemnification provisions in the trust, that's not going to suffice. And I'd like to hear Dick and Henry's comments on it. Even if there's general indemnification provisions in the trust, I don't think that's going to suffice for a trustee to have completely ignored the status of the policy for decades. I think some modicum of work must be done, not just paying a premium and issuing a crummy notice. Dick, Henry, would either of you like to comment on that?
Yeah, I've certainly had some cases underlying the indemnification or otherwise freeing the trustee from any specific obligation. I think that's a mistake to put in the trust agreement, but I'm not an attorney. But bottom line, in the cases, litigation cases I've been involved in, there certainly is responsibility here, and the beneficiaries will find adequate counsel to press that point forward. So we can't count on that kind of language in a trust to protect us if we're not doing what nominally is required to manage the asset to successful completion, which is the payment of a death claim whenever death occurs.
And just the word about the exculpatory clauses, I realize that it's the attorney's role and job and responsibility to protect the client, but isn't it better to notify the trustee of their duty rather than to absolve them of any responsibility with an exculpatory clause? I think so.
There's lots of different views on that, but I think the take-home point is anyone that's counseling or representing a trustee, they should be prudent in what they do and not rely on the exculpatory language. The exculpatory language is pretty ubiquitous in many trust instruments, and I think that oftentimes, especially when it's a family member trustee, the clients are looking to minimize the exposure, risk, and liability for a family member trustee, but I don't think looking to minimize unfair liability exposure is an excuse to basically give the trustee carte blanche to do nothing. So, I think this is going to continue to evolve as aging clients pass away and these neglected islets fall apart. So I'm sure we will all hear far more about this stuff than we like. Any other comments on?
Yeah, on page 34 that you see on the screen, I think the most important thing from my standpoint is that there should be in writing something very comparable to an investment policy statement. I call it a life insurance property management statement, but the essence of it is that in conversation with the grantor and the trustee, that there is an understanding, this isn't actually in the trust documentation, it's just an understanding of why did we select the policy or policies that we did to be the primary asset of this trust, and what did we discuss in terms of how such a policy should be managed for all of the things that we've talked about. We believe that there should be an adoption of a written investment strategy to protect trust assets, to protect the beneficiaries, and ultimately to protect the trustee who's doing the right thing. Henry, I think you wanted to talk about UPIA in here.
Just very briefly, I'm going to pick on the, could we just go back one slide to 34? Yeah, I'm just going to pick up on the last bullet, making certain that the entire trust portfolio is in substantial compliance with UPIA. Too many times we concentrate on the stock and bond portfolio, or we'll concentrate on a business, or we'll concentrate on a piece of real estate in the trust, but that life insurance is ignored. And I think one of the things that UPIA suggests very strongly is that all aspects of the trust be recognized and be looked at and be reviewed. And that certainly includes the insurance. And if the attorney or if the accountant or if the trustee doesn't have the necessary skills, well, then just go back up the one bullet right before that and retain the advice of the experts in the area that the trustee does not have adequate skills in. It seems to me common sense, but too often it's the root cause of the problem is that aspect is just not done. The insurance, life insurance, is just the orphan kid on the corner who's just ignored.
We're for everyone attending, we're 2 minutes past the hour. We're going to wrap up in 5 to 6 minutes and end by 1:10 at the latest. So just bear with us, and we're going to go a little bit further. And again, if you've missed anything or have to get off, a recording of this and all the materials and some supplemental materials as well will all be posted to the webinar section on Shenkman Law. It's www.shenkmanlaw.com/webinars within a week. Another comment just to finish up this point that Dick and Henry were talking about. Trustees should also give some consideration to informing beneficiaries of some of this analysis and some of these decisions. I think it's going to be much more difficult for a beneficiary to succeed in any claim against the trustee if the trustee made a reasonable attempt to keep the beneficiary apprised. And under some state laws, if the beneficiary is apprised and does nothing, after some reasonable period of time, they lose their rights to proceed against the trustee. And forgetting even the law, my experience doing this for 35 years, when beneficiaries are given some information about what's going on, they're a lot less likely to feel upset about a result if they were reasonably apprised of it as the decisions were made.
Marty, why don't we go to page 38 and let Henry just make a couple of comments about the prudent investor standards.
Sure. Prudent investment standards, just basically, it's a list of instructions. It's things that the trustee needs to do, needs to pay attention to. The type of risk involved, whether or not, if it's a variable policy, whether or not there should be diversification on the conservative side or some sort of perhaps more aggressive stance if the individual is a little bit younger. Looking back at the insurance performance evaluation, it's just based on the premium that's paid and the death benefit and the interest rates. Has the policy performed as expected? One of the things that we talk about is an adequate funding statement. I think that's one of the most important issues from your CPA's point of view or from a controller's point of view. One, can we afford the premium that the insurance individual has proposed? And if we can afford it, are the premiums sufficient in the policy, the premiums paid, are they sufficient to be able to at least make certain that that policy will stay in force at least up until, if not past, the individual's life expectancy? I think the whole point here is to just basically avoid surprises.
I would agree.
Keep in mind,
I would just say, Marty, if you take us to page 43, we can talk just a little bit more about what Henry has been referring to. One of the things that often doesn't get discussed very much is what is the source of the premium? If it's going to be cash gifts, anecdotally, in the fall of 2008, we didn't see a lot of cash gifts being made to ILETs as premiums were coming due. So it's important to know what the source of premiums is going to be. Is it a cash gift? Did we get lucky and be able to put the policy into a trust that already has sources of income? But knowing that in advance and then talking about what happens if the cash gift isn't forthcoming. Certain kinds of policies like guaranteed death benefit UL don't have a grace period. So if there's a chance that gifts will not be made on time, that would affect the kind of policy being chosen.
Let's we need to wrap up. Henry, would you like to make any last minute comments? And then Dick?
Sure. I'm just going to say that the goal of a TOLI review is to just basically make certain that the policy outlasts the insured and that things have changed. And what was good back then may no longer be good today, or may no longer be what's in the best interest of the client today. Just in closing, I'd like to thank, I've learned one or two, I'd just like to thank both of you, and just like to mention to our attendees that from my point of view, if anyone would like some additional information, you might take a look at the handout where there are several recent articles written on the subject. And as Marty mentioned a little while ago, there was also a book written called The Advisor's Guide to Managing Risk, Life Insurance Policy Crisis. And there's happens to be a discount flyer in that handout. And if any of you are interested, you can certainly take advantage of that just by clicking on the links. And I thank you for your time and attention. Thank you.
Dick?
I would just add in closing, we've talked a lot about crisis management, and it's really important to do that. But I think the other side is ILETs will still get created for a variety of reasons, regardless of what happens in Congress with pending legislation. And so with the kind of information we've reviewed today, to be able to take an understanding of the fact that the illustration is not the policy, that whatever the illustrated plan premium is unlikely to be the lifetime sustaining premium, to take all of this information into account and build in the right factors. If you want to select a personal trustee that doesn't have a lot of management capability, then build in some extra funds in the annual gifts so that the trustee can hire a suitable insurance analyst to help be part of the advisory team that is going to evaluate the entire trust, and especially the trust property, the life insurance policies on an ongoing basis.
Let me make one really important point before we close. It's a couple of part point. One, if tax reform goes through, which seems to be a growing possibility, and the exemption increases significantly, we need, as advisors, to reevaluate every single insurance trust and every single insurance policy that even had as a tangential purpose paying estate tax. It doesn't mean to cancel the policies. Quite to the contrary, I'm concerned that whatever happens with this round of quote-unquote tax reform in 2020, we may see a revisiting of all this and things may yet change. So I think we need to be very careful about counseling clients before they get rid of a viable insurance plan. But certainly a change in the law that tax reform anticipates a doubling of the exemption may very well be an important inflection point to have a thorough review done of these policies so that we can properly advise clients. If the policy is in jeopardy now, maybe the action that should be taken may be different in light of tax reform than if the policy is not in jeopardy. If the policy can be repurposed into a savings tool, a tax advantage planning tool, so on and so forth, an asset protection tool, it may be viable and appropriate, even recommended to retain the existing plan or shore it up, as Dick and Henry have talked about, regardless of what happens with the estate tax. So hopefully you've all found this informative. I've certainly learned a lot. Again, all the materials will be posted to Shenkman Law /webinars within the week, and please feel free to refer to them and recommend to your colleagues to look as well. If you have any comments or suggestions, my email is here. I welcome your input and thoughts on the program. I'd like to take this last minute and just thank Henry Montag and Dick Weber for their great insights and all their help with the materials, and thank you all for joining us. Take care.
Thank you.
Thank you.